Good afternoon. My name is Malia Brink, and I am here to welcome you to a series of free webcasts on representing juveniles in adult court presented by NACDL, the National Association of Criminal Defense Lawyers, in partnership with the Juvenile Law Center and the National Juvenile Defender Center. We would also like to acknowledge that these programs are only available with the support of our funders, the Foundation for Criminal Justice, the Ford Foundation, and the Open Society Foundations. The free nature of these programs reflects the commitment of the organizations and the faculty involved in ensuring quality representation for all juveniles and youthful offenders charged with crimes in adult court. We are coming to you live from NACDL headquarters in Washington, D.C., but through the wonders of technology, we are currently reaching people in at least 40 states, the District of Columbia, and Puerto Rico. This program will be the first of a series of 3 initial programs. The program today is Adolescent Development 101, and I'm going to give a brief introduction to the speakers before turning it over. You have their entire bios in your materials. Dr. Jennifer Woolard is an associate professor of psychology at Georgetown University and a research fellow at the Center for Social Justice. She obtained her PhD in developmental and community psychology from the University of Virginia, and her research focuses on adolescents and families in legal contexts, including police interrogation, culpability, the attorney-client relationship, and the role of parents in adolescents' legal decision-making. And Marsha Levick, who will be framing Dr. Woolard's presentation today, is the co-founder of the Juvenile Law Center, the oldest public interest law firm for children in the United States. She currently serves as its deputy director and chief counsel, and she is a tireless advocate for children's and women's rights and a nationally recognized leader in juvenile law. Marsha?
Thank you, Malia, and thank you to NACDL for providing us this opportunity to work with them. The title of today's presentation is Adolescent Development 101, so in my effort at providing a framing for Dr. Woolard's comments, what I'm going to do is about 5 minutes of Juvenile Law 101, because I think that this is really essential to understanding really how we got from 1899 to 2012 and the discussions that we're going to have over the course of the next 3 webinars today and tomorrow. First Juvenile Court was founded in Cook County in Illinois in 1899, and I think it's interesting to note that when the first Juvenile Court was founded, it was created actually with the idea that kids are different. And while we think of that as our mantra today, when we think about kids in both the juvenile and the criminal justice system, the reality is that that was as much a part of what spurred the original creation of the Juvenile Court over 100 years ago as it is a driving reality today. The first Juvenile Court functioned throughout the country for about 65 years until 1966, with really very little input from the courts, very little oversight, very little concern for children's constitutional rights. The court was created with the idea that it would provide treatment and rehabilitation, it would separate juvenile offenders from adult offenders, and it would provide an informal environment in which kids would be adjudicated delinquent, and it would provide, hopefully, for very limited consequences for kids as a result of those delinquency adjudications. In 1966, the Supreme Court decided a case called Kent versus United States. Kent was a case in which the Supreme Court decided for the first time that the decision to transfer a child into the adult criminal justice system was one that mattered, that had great constitutional weight and consequences. And the Supreme Court required that before a child could in fact be transferred into the adult criminal justice system, certain due process safeguards had to be met, including right to counsel, right to an opportunity to review the materials that the state would present in support of transfer, right to an opportunity to appeal that decision and to review it. When a year later the Supreme Court decided in re Galt, the Supreme Court for the first time really took the bold step of talking about children as being people under the Constitution. Seems like an odd thing for us to talk about now, but in 1967 that was actually a pretty novel concept. The court also, in articulating children's rights under the Constitution in the course of delinquency adjudicatory hearings, essentially provided basic fundamental rights. Children had a right to counsel, they had a right to confrontation and cross-examination of witnesses, they had a right to have their hearing transcribed, they had really the right to all of the basic due process safeguards that I think especially the criminal defense bar, ahead of the juvenile defense bar, has taken for granted for decades with respect to the rights, the constitutional rights of criminal defendants. For the next 30 years or so, the Supreme Court essentially left the juvenile court alone. I think that what we saw after 1967 was really what we refer to as the constitutionalization of the juvenile court. Over the course of the next several decades, every state in the country adopted the constitutional requirements that the Supreme Court set forth in In re Galt, and every Juvenile Court Act included those fundamental rights of right to counsel, cross-examination, etc. In the late 1980s and the early 1990s, we saw a dramatic rise across the country in violent offending by both juveniles and adult offenders. And the consequence of this rise in violent offending, which I think most criminologists today recognize as really being a product of the very lethal combination of crack cocaine and guns, easy access to guns in our communities, that rise in violent offending saw another shift in the way that we thought about juvenile offenders and the juvenile justice system. Essentially what happened during the 1990s was that we saw another wave of reform, legislative reform, which was the creation across the country, amendments to juvenile court acts in virtually every state, which really pushed many more kids into the adult criminal justice system, really provided for, depending upon either the age of the offender, in some jurisdictions as young as 13 or 12 years old, looking at the offense that the juvenile was charged with, so there was a particular focus on violent offenses, murder, aggravated assault, armed robbery, rape, the sort of category crimes, FBI crimes, violent offenses. And we saw really an enormous influx in the number of kids who were now being tried as adults through the 1990s. That event and that rise in juvenile crime actually prompted the MacArthur Foundation in Chicago to create something called the Adolescent Research Network, the MacArthur Research Network on Adolescent Development and Juvenile Justice. This is really critical, I think, to where we are today and to the remarks that we're going to hear from Dr. Woolard in a couple of minutes. The MacArthur Foundation created this network with an eye towards using a scientific approach to thinking about the implications of adolescent development for the construction of a rational juvenile justice system, for the construction of rational juvenile justice laws, policies, and practices. That research network was primarily focused at the time on issues of competency, so competency to stand trial, competency to waive rights, issues of culpability, and the impact of particular interventions for kids charged with crimes, and primarily kids in the juvenile justice system. What I think the MacArthur Foundation probably didn't anticipate is that their research ended up having a much more profound effect on the rights and the prosecution of children in the adult criminal justice system. And we saw the first impact of that research and the very profound impact of the work of the research network in 2005. In 2005, the Supreme Court decided Roper versus Simmons. Roper versus Simmons was the case in which the Supreme Court struck the juvenile death penalty, and it was a critical case because, of course, what had happened is we saw more kids moving into the adult criminal justice system during the 1990s. They bore the full brunt of criminal penalties. So kids were not only sentenced to very lengthy terms of year sentences, they were sentenced to life without parole, and they were sentenced to death. They were eligible for the death penalty in many jurisdictions across the country. Roper was the first case in which the Supreme Court struck the juvenile death penalty for all juveniles under the age of 18 at the time that their crimes were committed. The Supreme Court relied extensively on research findings by the MacArthur Research Network. It spoke specifically about three particular findings of the research network having to do with adolescents' immaturity of judgment, adolescents' susceptibility to negative peer pressure, and adolescents' unique capacity for change and rehabilitation because of the transient nature of adolescence. Roper was followed in 2010 by Graham v. Florida, another U.S. Supreme Court case in which the Supreme Court struck the imposition of life without parole sentences for juveniles who were charged with non-homicide offenses. 1 year after 1 year after Graham, the Supreme Court decided another case, not a sentencing case, a case JDB versus North Carolina, in which the Supreme Court again relied on the findings of the MacArthur Research Network, the findings related to both the developmental aspects of adolescence as well as some of the more recent neuroscientific research and brain imaging that was beginning to come into the forefront. And in a case involving whether or not a child should have been Mirandized during the course of an interrogation inside a school building by police officers and school resource officers, the Supreme Court found for the first time that the Miranda custody test required that the age of the juvenile suspect be considered in determining whether or not the juvenile would have thought that he or she was in custody, and therefore whether or not the Miranda rights should have been read to this particular juvenile. That really brings us to the present, and what we hope to do over the course of the next several hours of webinars today and tomorrow is to really take the research that started with a goal of informing and creating a better and smarter research-driven, research-informed juvenile justice system, and realizing that much of the work to be done and much of the implications of the research that we now know about adolescent development has very significant consequences for the adult criminal defense bar and for kids who are in the adult criminal justice system. Approximately 250,000 kids are tried every year in the adult criminal justice system. Many of them get there as a consequence of legislative mandates that have trimmed the boundaries and the jurisdiction of juvenile court, but many of them also get there as a consequence of judicial decision making. As a result of those transfer decisions, these kids who are in the criminal justice system, again, are still subject to very significant sentencing and sanctions that would be imposed on adults under the same circumstances. So what we hope to do over the course of the next several sessions is both to give you the introduction about Adolescent Development 101, and Dr. Woolard will flesh out the very brief things that I touched on, and then specifically to turn to issues of transfer and sentencing, which are two of the most critical points at which kids interact with the adult criminal justice system, and where we believe the adult criminal defense bar can really make a difference by taking account of the findings and the research that has come to the forefront as a result of much of the work that Dr. Woolard and her colleagues have been involved in. So, Dr. Woolard.
Great. Thank you very much, Marsha, and thanks to NACDL and NJDC and the Juvenile Law Center for putting these webinars on and giving me the opportunity to spend a little time, at least electronically, with you all talking about these issues. Now, I start with giving you Adolescent Development 101 with a bit of trepidation because I'm assuming each of you experienced adolescence at some point in your lifetime. So you have some personal direct experience about what this is like. Some of you may be parents of adolescents. But what I really want to do today is to try to bring the scientific basis to bear on what we know from the empirical research, which is remarkably consistent probably with your own experience, and to talk about how aspects of that empirical research, both the behavioral research and, as Marsha mentioned, the growing amount of brain-based or neurobiological research, and to talk about what its implications are for the kinds of issues that you all are dealing with in terms of representing juveniles in adult court. I'm going to move through the different topics that Marsha talked about at a little bit of a rapid clip so that we can get through them during this time period. If you have questions of clarification, you should feel free to send those along if you're on the webinar, to type those in, and we'll try to get those taken care of, or for the folks that are here in the audience to pipe up with those. I'd like to save the kind of substantive, detailed questions until the end of the presentation so we can get through all the material and then deal with some of the complexities and examples that you all might raise. But please feel free, err on the side of sending those questions in so we can make sure that we'll be clear on what's happening. So we're going to try to move from academic jargon to practical value. I'll use a little bit of jargon and hopefully I'll translate it for you in a way that's going to be helpful and meaningful. As Marsha mentioned, the MacArthur Research Network and all of the folks that are affiliated with that really wanted to bring a developmental perspective to the kinds of questions that might inform the way that law and practice moved forward. So let me give you 3 examples of the kinds of developmentally oriented questions that we asked. At what age do individuals develop the capacities necessary to be held fully responsible for their actions? So dealing with the issues of culpability. At what age do individuals develop the capacities to be a competent defendant? So looking at competence to stand trial as well as to waive Miranda and so forth. And then what do we know about the capacity of youth to be rehabilitated at different ages? So looking at this issue of amenability to treatment and so forth. I'm going to focus the first part of my talk drawing on the research that we did regarding competence. But first let's start with why juveniles are uniquely positioned, I think, and face unique developmental challenges as defendants, particularly in adult court. And I like to define this in terms of 3 roles or jobs that they have simultaneously here. The first, of course, is as a defendant, right? And so they have constitutionally protected rights. There are decisions that only they can make about their case, contrary to what, as we'll talk a little bit about later, their parents might think. These are decisions that are vested in the youth themselves. But simultaneously, as being a defendant, they're also an adolescent. And so we know from the developmental research that preceded our network and that we expanded on in this research that there are incredible amounts of cognitive and psychosocial capacities that are developing and changing during this time that are quite relevant for the kinds of decisions and actions that kids engage in if they decide to engage in a criminal act and as a defendant as they're moving through the system and making decisions about their cases. And then something that distinguishes kids, again, from your typical adult defendant is that they are still children and they have parents or caretakers or guardians, someone who's legally responsible for them and whom they are legally dependent on and subject to the control and authority of those parents. So that adds another wrinkle into the interaction that you may be having with those clients. So a developmental perspective comes at this from a slightly different angle than, let's say, a traditional criminology or psychology perspective might come to looking at adult defendants. So in the interest of full disclosure, I want to talk about the assumptions that that developmental perspective brings and that undergird the research that I'll be presenting to you today. The first is that we begin with the premise that juveniles are different from adults in fundamental ways. So this is the presumption that comes from decades of research on development, from experience, from the wisdom of the ages, whatever you want to call it. We know that kids are different in fundamental ways. I do want to emphasize that this difference is linked both to their maturation as they're growing older to be adolescents into adulthood and from the experiences that they have as teens. So it's not just an individual internal unfolding of development, but it's an interaction of that development with the experiences they have in their families, neighborhoods, and communities as they grow up. The second is that the point of this research is to describe and document using science, using empirical data, as separate from our personal experience, the nature and extent of these differences. All right, so we're not just relying on anecdote or experience, which is important, but we can say, what do we know systematically about these differences between juveniles and adults? And then in partnership with law and policy colleagues, attempt to articulate what some of the implications might be for a scientific understanding of adolescent development, for legal policy, and for practice. So let's start with how these assumptions might play out when juveniles are tried as adults. So the first assumption, or one of the first assumptions, is that for a juvenile to be tried as an adult, that at the time of the offense, that juvenile possessed the capacities that are necessary for adult levels of blameworthiness. So this is the culpability question, right? So from the very beginning, we're presuming some adult-like nature and capacity in order to be held responsible, comparable to an adult. At the time of trial, and here I say trial, but really at any of the legal proceedings that move forward with the case, that the youth possesses the capacities necessary to be a competent defendant in that case. And then finally, at the time of sentencing, that youth possesses the qualities that are consistent with the purposes and the implications of adult sanctioning. So these might seem to you, at least on their face, what when I teach Psychology 101, I've become affectionately to know as the test, which is when I say something that students in the back of the room will raise their hand and say, well, duh, didn't everyone know that? But I want to move us past the duh idea here and to say that these assumptions then carry forward very important implications for our understanding about juveniles' capacities and how they might operate and function in an adult criminal justice environment. Also for the juvenile environment, but we'll focus on the adult criminal environment today. It can be a long pathway, though, from basic developmental research to an individual case that's on your desk in front of you. And so what I want to briefly do is just to illustrate how we might move from the circumstances of an individual case down to the kinds of variables and concepts that we as scientists are going to measure, both so you can see how we begin to translate it and also so you can see the distance so that we can come to an appreciation of the degree to which the science will be applicable. And I'm going to use the Yarborough v. Alvarado case, which is now superseded by the JDB case. So I will give you the disclaimer that I'm not the lawyer, so this is not legal advice, but just want to use this as an illustration in part because this is one of the cases that sparked work in my lab to really examine some of these assumptions that courts seem to be making. So if we start with the individual case, which had to do with a youth charged with a serious crime who was brought to the police station by his parents to be questioned, was questioned, eventually confessed to that, to participating in the crime and so forth. And then one of the questions was the degree to which he believed that he was in custody, that he had been given appropriate warnings and so forth. So one of the legal issues in that case that was dealt with in the opinion and in the dissent was whether a reasonable person would have felt at liberty to end the interrogation and leave. Right? So some of the anecdotes around that case were he asked if he could go use the bathroom. They said no. His parents wanted to see him. They weren't allowed to, and so forth. So one of the larger questions was, did he feel like he was in custody or not? Some of the assumptions that were made that came out in that opinion was that age would not be a determinative factor in whether someone believed they were in custody or not. And the majority felt that the fact that his parents brought him and so forth would have had no effect on his capacity to feel free to leave. So with that non-lawyer brief description of the situation in that case, then hopefully you can see as we move now into these blue boxes in this ladder that we can identify psycholegal constructs or ideas that cross between psychology and law that would be relevant to understanding the kid's capacities. So whether he engaged in reasoned or prudent thinking, whether he could understand the future implications of decisions that he was making, what the influences of parents and authority figures may be, and then we can move one step back from that to basic developmental capacities, things that we know grow and develop during the course of adolescence that might be relevant. Susceptibility to authority, obeying authority, orientation towards the future, and different kinds of decision-making and the influences on adolescents' decision-making. So again, this is simply a way to show how we try to draw the connection between the facts of an individual case, the larger legal issues, and then how we as scientists can bring science to bear, and empirical science to bear, to try to inform the connection between all of these layers. So one of the first questions is why understanding adolescent development should influence justice policy and practice. And again, going back to this framework of competence and culpability and amenability, based on the research that existed before we did this legally specific research, there was good reason to believe that adolescents might be less competent than adults because of these growing developmental capacities that would affect their ability to serve effectively as defendants. That by their very nature, teenagers are continuing to grow and develop, which means we don't know how they're going to turn out, which makes the prediction of their future behavior much more difficult than it might be if we were looking at a fully formed adult. And then finally, that adolescents might have certain limitations or deficiencies in their capacities that would diminish or mitigate their criminal responsibility. So Marsha mentioned the Roper case and how that drew on both the behavioral and the neuroscience research. And so borrowing a little bit from my colleague Larry Steinberg at Temple, in his discussion of this, why the neuroscience was thought to be important in Roper v. Simmons for a couple of different reasons, right? One is that arguing that adolescents don't control impulses is not the same as arguing that they can't, right? That volition, that there's a difference between having the capacity and exercising the capacity. And then, as Larry suggests, that policymakers may use science like a drunk uses a lamppost for support, not illumination. So the idea that science could come to support the conclusion that was being drawn here to demonstrate that it did, in fact, have a factual nature. Science can make common sense and the anecdotal evidence and experience that I was mentioning before seem more credible, and that, and this is not just because I'm not a white coat lab scientist, but that laypersons often find, we find actually from some research, that neurobiological scientists with the white coat in the lab with pictures of brains sometimes tend to appear more credible than those of us that are not engaging in that research. So these are some of the reasons why the brain research may have really had terrific timing in terms of being important in the Roper case. Before I go on now to talk a little bit about the specifics of the developmental research and the implications, I want to give you some cautions about a developmental perspective and give you some limitations. One of the main things I want to say is that we shouldn't think of immaturity as a diagnosis. Okay, so it's not a condition in the same way that we might think of a mental illness or other impairment. Why do we say that? Well, because immaturity is relative. Okay, so if we say that someone's immature, we have to be thinking of some reference group against which we are comparing that person. Immaturity is not all or none. It's not a you have it or you don't. Kids, as we'll see, can develop to different degrees in different areas of their cognitive and psychosocial lives, so they may be more advanced in some areas than in others. And we also know that age does not exactly and clearly define the degree of maturity or immaturity. So we could have two 15-year-olds who exhibit very different degrees of development and maturity in various ways. And we also know that mental illness and mental retardation can produce impairments and delays in older adolescents that result in their functioning much more like adolescents who are younger than they are. Okay. I also want to give one more caution, which is that to beware the desire or the trap of taking group-level data about what the average adolescent is like and applying it to an individual case. So simply because we have data suggesting that adolescents of certain ages are less mature than adults doesn't necessarily mean that a particular adolescent in front of you at this moment is, by definition, psychosocially immature. That there's variability within the world of adolescence, and so these data will give us a sense of what adolescents as a whole are like, and what is more likely than not to be true, but there will always be individual variation in that. So there can be a very mature adolescent, there can be a very immature adult. So we just want to be cautious. These data are not meant to substitute for clinical individual evaluations of clients in looking at their own capacity at a given point in time. Okay, so with all of that, then let me lay out here for you the different concepts that I'm going to be using today in the spirit of that ladder map that I showed you with the Alvarado decision. So we'll be talking about implications for competence, amenability, and culpability, and particularly around mitigation with culpability. I'm going to be using a couple of developmental concepts or constructs to illustrate the implications for those legal concepts. I'm going to talk about cognitive control, psychosocial maturity, I'm going to talk about intelligence, and I'll be bringing up in several places some caveats around mental illness or mental retardation as a reminder for the implications that those conditions may have for adolescent performance. Okay, so next I want to give us just a brief tour into the recent decade or so of research on adolescent brain development. This is not meant to be taken literally scientifically as a literal description of the way the systems are in the brain, but really more as a framework for helping us understand what the important components are in the brain that are relevant to the kinds of concepts that we'll be talking about today. So it can be helpful, I think, to think about two distinct sets of brain systems that are relevant to adolescent behavior. And they mature at different timetables, and they're in different regions of the brain. So I'm going to be referring to these as we talk about psychosocial maturity throughout the webinar today. The socio-emotional system, which involves the limbic system, ventromedial and orbitofrontal areas of the frontal lobe, and the cognitive control system, okay, which mainly involves the upper outside area of the frontal lobe and the parietal lobe. So I'm trying to show you on my brain, this is not incredibly effective, but that the systems we're talking about are located in different parts of the brain. Let's start with the socio-emotional system first. So this is the system within the brain that's responsible for emotions, for processing social information, right? So reading cues about individuals and interpreting those cues, and is also involved in our interpretation of and response to rewards and punishments. So in here I don't mean necessarily just punishment in the criminal justice context, but positive things and negative things that are happening. The components of this system undergo some very significant changes in early adolescence, okay? And it appears that many of these changes are related to the hormonal changes that happen in puberty. So here we're really talking about, let's say, the 10 to 13 age range, okay? What we might think of as preteen into early teen, again, recognizing that there's variability among adolescents in when they experience these changes. And these changes in the socio-emotional system are associated with some of the behaviors that we stereotypically associate with adolescence, right? Increased sensation seeking, so seeking out novelty, seeking out thrills and excitement. Increased levels of emotional arousal, so highs are higher and lows are lower. And it's easier to reach those highs and lows, okay, that happen more quickly. And increased attentiveness to social information, right? So the paying attention to what other people are thinking, what we think other people are thinking, this, when you're walking in the room, assuming that everyone's looking at you and so forth. So all of these kinds of socio-emotional capacities are a part of this system that's undergoing significant change in early adolescence, okay? And I'll come back to this issue, but I want to point out that there are important developmental reasons why these things happen, okay? So even though sensation seeking, for example, may lead to types of risky behavior, there are important developmental reasons for kids to be learning new things, experiencing new things, getting out of the house, right? and growing and developing on their way to early adulthood. Okay, so that's the socio-emotional system. Now let's talk about the cognitive control system for a moment. This is sometimes referred to as the CEO of the brain, or you may have heard of executive function, right, as a way to describe these kinds of capacities. This is deliberate thinking, right, weighing costs and benefits, thinking ahead, controlling impulses, being planful. And what we find both from the brain research and the behavioral research is that it appears that this system, in contrast to the socio-emotional system, develops much more gradually and develops from pre-adolescence through adolescence well into the early and mid-20s, which as a college professor I can attest to from my own personal experience as well. Right, these are the things that insurance companies have known for a long time, right, which is why 20-year-olds can't rent a car. The idea that this deliberative, planful system is still coming online, still expanding, still growing, well into the early 20s. Ultimately, what the development of this system does, and its integration with the socio-emotional system, results in better impulse control, better emotion regulation. So, the extreme of lack of regulation are temper tantrums that we see in young kids, right? But the idea of being able to control and modulate or moderate our emotional reactions. More foresight and planning ahead. So being able to think through, if this, then this will happen, and this will likely happen. So here are the consequences that might be 3 steps ahead. And better reasoning. Being able to think about different perspectives and reason through what the implications might be. So let's talk about what this developmental perspective then, in thinking about socio-emotional factors and cognitive control factors, how this might play out using competence to stand trial as an example. So the research that I'll talk briefly about in a few minutes really points out that kids and adolescents are developing in ways that are relevant for questions around capacities to be competent to stand trial. From the biological research, we know that there is structural and functional brain development that is continuing during this time for that socio-emotional and cognitive control system. We know that cognitively, teens are developing their reasoning and problem solving, part of why they can be so argumentative during this time period, right? Fleshing out these capacities for reasoning and problem solving. And then psychosocially, thinking about things like the influence of peers and the relationship to authority figures, which could relate to interactions with attorneys, with judges, with police officers, with co-defendants, risk perception, all right? Making a decision about a plea agreement offer, thinking about the risks and consequences of various activities as a defendant, and time perspective, right? So teens generally have, compared to adults, a foreshortened time perspective in which the now is much more important than the future, which to a certain extent makes rational sense when you think that they haven't lived for a very long time. So the future and long term has a different meaning for adolescents than it does for adults. So with this as a little bit of background, let me give you a couple of results that our MacArthur Research Network found in our adjudicative competence study that took place in the early part of the 2000s. We had data collection sites in 4 places around the country. We interviewed kids and adults who were in pretrial detention or in jail awaiting their trial, and we interviewed kids and adults that lived in communities from which those jailed pretrial defendants came. So we had a community sample that wasn't currently engaged in the system, but appeared similar demographically to the kids and adults that were in the system, and we gave them some measures of their abilities to be competent to stand trial, along with those measures of psychosocial development, intelligence, and so forth that I was just describing. So heading into that research, we had 3 questions, which again I want to reinforce were crafted at the intersection of science and practitioners, saying here are the relevant questions that we have around competence to stand trial for kids. Are kids any more likely on average than adults to have deficits in their capacities to be competent? If they do, at what age do we see those? And where specifically do we see those deficits? So let me orient you to this graph. The MCAT-CA, the MacArthur Competence Assessment Tool for Criminal Adjudication. This is actually one of the first times that this instrument, which was developed with adult populations to measure understanding, reasoning, and appreciation as components of legal competence, was extended for use in juveniles as well. So this is one of the first sets of data in which we're able to compare kids' performance on those capacities to adults. We had 4 age groups within our sample: pre and young teens, age 11 to 13, 14 to 15-year-olds, 16 to 17-year-olds, and then 18 and up. Our adult comparison was specifically kept at the young end because we wanted to make it difficult for kids to look different from adults, right? It probably would have been really easy to get a bunch of 50-year-olds and to compare them to 12-year-olds, but we really wanted to take that legal line of 18. The assessment tool is set up such that we ask questions about competence abilities. What's the role of a lawyer? What's the role of a defense lawyer? What's the role of a prosecutor, for example? And then the participants give us their answer. Then we score that answer as to whether it's correct. If it's not completely correct, we then teach them what the correct answer is, right? Because to be competent, you don't have to know everything ahead of time, but you have to be able to learn what you need to know in order to function. And so this graph shows you the percent of each age group that scored as seriously impaired on the understanding questions before in the dark red and after in the light tan, the teaching that I just described. So initially, almost 60% of the 11 to 13-year-olds scored in the seriously impaired range, compared to about 20% of the adults. Okay? After teaching, you can see that that difference shrinks, but is still significantly different. So almost 1/4 of our 11 to 13-year-olds still scored as seriously impaired on the understanding that's relevant for competent to stand trial. Okay. Here's a graph that just looks at the kids and adults that were in pretrial detention or jail. Okay, so they had been arrested and were awaiting their trial. And it brings together their IQ and their understanding. One of the things that we found in this study was that this is one of the things that would qualify as the DUH test, that folks with low IQ have poorer understanding than folks with average or above average IQ, okay? But what was really compelling here was that the effect of low IQ was much more serious for juveniles than it is for adults, okay? So here you'll see those same age groups, but each age group is split into an IQ category, okay? 60 to 74, 75 to 89 on the IQ scale, and then 90 above, which would be average or above. And what you can see, for example, in the 11 to 13-year-olds is that low IQ, that dark red bar, IQ 60 to 74, low IQ 11 to 13-year-olds, almost 60% of those scored as seriously impaired on either understanding or reasoning, whereas approximately 30% of the young adults with similarly low IQ scores scored as seriously impaired. Okay? So IQ is important across the board, but what we want to emphasize here is that it can be a double whammy for kids, that if you have a combination of age and low IQ, there's apparently more impairment that happens for kids than there is for adults. Okay? I should note that performance on these scales was not related to gender, race, ethnicity, which of the sites across the country that the youth and adults came from. It was not related to socioeconomic status. It was not related to prior experience in the justice system. So folks who had been arrested before or had been held overnight in detention before did no better on understanding or reasoning than folks who had not had that experience. And we also were able to measure behavioral and psychological and emotional problems, symptoms of that, and we didn't find differences by that either. So we really view this as being a true developmental difference, or age-based difference that we see here. So this deals with the legal standard of competence, right? That very basic level of capacity that one has to have in order to be competent to stand trial. But we were also interested in understanding kids' performance compared to adults in their functioning as a defendant and in their decision-making, things that might not necessarily be considered in an evaluation for competence for adults. But given all of that developmental research that I talked about before, right, that with the psychosocial factors, decision-making, future orientation, and so forth, we had a real sense that kids would perform differently in how they thought about and made decisions about their role as defendants as compared to adults. So we developed another measure that at the time was called the McGen, the Judgment Evaluation Narrative, that went into greater detail about judgment and reasoning in 3 situations that the interdisciplinary group agreed would be fairly common experiences. So in terms of being questioned by police, in terms of talking with an attorney who's representing you, and considering a plea agreement and making a decision about that. And we scored their free responses, okay? So we just asked, here's a situation, what would be the best thing to do in this circumstance? Give us the best choice. Should you talk to police? Should you remain silent or do something else? For example, in the interrogation vignette, okay? And then we asked them, why is that the best decision? And followed up so that we could get some sense of their understanding of risk, right? How much they were willing to take risks, how much they understood risks, how much they were thinking about the future when they made decisions. And we also had some questions that dealt with peer influence as well, the role of peers in their decision making. So here's one result from the vignette that talked about Joe, who with some friends from the vignette participated in an armed robbery, was brought to the police station, and then we asked the youth and the adults in the study, what should Joe do? okay, when brought in for police. And we classify their responses into 3 categories: talking and confessing, talking to the police but indicating that they were going to lie or were going to deny involvement, and then remaining silent. And if you compare the dark red bars with the light pink bars, you can see that it's almost a complete X or a complete cross in terms of youngest adolescents. Almost 60% thought that confessing to police would be the best thing to do when you were brought in for interrogation. And only about 30% of our young adults thought that. Almost 70% of the adults thought that remaining silent was the best thing to do, and only about 15% of the youngest juveniles did. So you can really see that there are incredible age differences. If we're thinking of the story of a kid walking into an interrogation, or being brought into an interrogation, right? The idea about what would be the best thing to do based on our data suggests there are very important and significant age differences about thinking about what's best walking into that situation and making that decision. When asked about why they thought their choice was the best thing to do, kids tended to focus on, if Joe talks to the police right now, he'll probably get to go home, they'll let him out, he'll get to go be with his parents. If he does what they tell him to do, they'll probably go easier on him later on and things will go well. Okay? Adults, regardless of whether they decided to remain silent or to talk, we're really focusing more often on how confessing could affect the sentence that Joe might receive later on, how it would affect the process, and so forth. So the quality and the type of their reasoning was very different. This graph talks about what we asked would be the best thing to do in response to a plea offer from the prosecution. And I won't go into the details about the offer right now, except perhaps to say, because of our focus on kids in the adult system, that we actually originally created a story that involved transfer to adult court, and that was part of the plea, and decided that was too complicated and couldn't put that into the story. The legal scholars and the scientific scholars had a long discussion about that, so it had to do with remaining in juvenile court. But the notion of the complication of considering transfer is one that we can talk more about. And here we see, again, that almost 80% of the youngest kids thought that taking the plea would be the best thing to do, whereas for our young adults, they were evenly split 50-50. Now, I should say, from our perspective in designing the research, there was no right answer to this question. So I'm not trying to make an argument that taking a plea is wrong or that refusing a plea is right, but simply to say that there are incredibly large age differences in how the teenagers and the adults were thinking about what the best choice would be. Again, thinking about the story of an individual kid considering a plea agreement, what they're thinking about going into that decision appears to be very different depending on how old they are. When we asked about their reasoning for the plea agreement, the kids tended to do a straight up addition-subtraction calculation, right? The plea agreement would result in 2 years. That's less than 6 years if I go to trial and found guilty. So 2 is better than 6, so take the plea. Adults tended to have a more complex set of reasonings about it, right? Well, if this is his first offense, if his lawyer is very good, what the judge might be like, and so forth. So they brought in a lot more complexity to the decision rather than just 2 is less than 6. Therefore, the plea would be more important. So let's then step back from those specifics. Those are illustrations of the kinds of age differences that we found, and talk about how these aspects of immaturity might influence kids' decisional capacities. I mentioned influences on perceptions of authority, right? So this can refer to you as the attorney for the youth, perceived as an authority figure, deciding what to tell you, what not to tell you, whether to trust you, how much to trust you, and so forth. Whether youth approaches you and other authority figures in a very compliant mindset. Yes, I'll do whatever. Yes, that sounds like a great idea. Or a very oppositional set. I don't care what you say. I'm going to disagree with everything that you suggest. Okay? Again, one of the hallmarks of adolescence and the psychosocial immaturity in terms of responding to authority figures. We also saw that psychosocial immaturity can affect how you weigh rewards and punishments, gains and losses, right? For adults, the involvement of peers or the reaction of peers in a crime may be much less salient or important than for 14-year-olds, right? The judgments about short and long-term effects of their decision. Again, if you think back to the question about police interrogation, the chance of going home immediately versus spending the weekend in detention appeared to be much more salient for the youngest kids than it did for the adults. So that 48 hours means something much differently to a 14-year-old than it does to a 24-year-old. So to summarize that study and the illustrations that I gave you, and this is also based on some of the findings that we didn't go through today but are available in some of the publications, is that when we focus just on the competence to stand trial capacities, the understanding, reasoning, and appreciation, okay, on average what we found was that the 16 to 17-year-olds did not look that different as a group from adults, but the 11 to 15-year-olds looked significantly different from adults across those different dimensions. Okay? So we saw a greater risk for incompetent student immaturity if we were talking about kids 14 or under. Okay, so just by virtue of their age. Kids 15 to 17 with the low intelligence, so remember that double whammy that I talked about a few minutes ago, right? And the idea that the interaction of low IQ and adolescence can have a stronger effect for kids than it does for low IQ adults. And then also, and we weren't studying specifically mental disorders, but youth that have significant mental disorders that create developmental delays would also potentially be at risk for developmental incompetence, which is incompetence that results from age, not from mental illness or other kinds of impairments that we see with adults, okay? And the presumption is that incompetence that results from age is something that one could eventually overcome or grow out of, right? That it's not a permanent state. When we do see differences, they more often occur in the dimensions of appreciation or rational understanding, okay, of competence, and in the decision-making rather than in just the straight-up factual understanding, okay? So many kids can understand what is a judge, what is a defense attorney, and so forth. But once we move into the appreciation, which of these facts is more important to tell your lawyer, how does this apply to you, and so forth, that's where we begin to see many more of the age-based differences. Okay? So that's the finding around the competence to stand trial, but remember we talked about decision-making and psychosocial factors that we normally don't consider when we think about adults. What we learned from those measures, okay, is that adolescents were much more likely than adults to be compliant with authority. So when we asked them what the best choice was in talking with police, talking with attorneys, concerning a plea agreement, adolescents were much more likely to take whatever choice the authority figure suggested was the right one, okay, than adults were. And younger adolescents in particular had less capacity to understand and articulate the risks and consequences of the choices that they faced, particularly thinking about long-term consequences as compared to short-term consequences. So they were less able to identify those than the adults were. Okay. As a caution, again, in thinking about kids' developmental capacities and the implications for competence, the mere fact that someone is 13 doesn't automatically mean that they're incompetent, right? So and again, competence is the legal standard that you all as practitioners are the experts in dealing with. From the scientific standpoint, what we can contribute is that those actual abilities, your individual client's actual abilities, are what determine or what influence competence, not just their age. And we need to understand whether deficits that they may exhibit are related to immaturity or are related to something else like mental illness or mental retardation, okay? And whether or not those deficits can easily be remedied, okay? Is this something that one could be restored for? In some situations with adults, impairments in competence abilities due to mental illness can be remedied through treatment, right? It's not clear that one can remedy being an adolescent and improve them to the point of being competent if the risk to their competence is because they are not fully developed adults yet. Okay? So in thinking about implications, moving to the practicalities, the research suggests that these risks for incompetence are increased when youth show any one of these following signs. Okay? Whether during pretrial contexts that you have, that the youth's behavior suggests that they might have serious problems or deficits in terms of memory or attention or interpretation of reality. Okay, so talking about perhaps delusion, serious mental illness, and so forth. If they have a prior diagnosis of mental illness or mental retardation that has required treatment in the past, that would be a red flag for thinking about risks for incompetence. If they've got prior IQ testing that shows them as scoring below 75, or if they have school records indicating they have a learning disability. And then with the straight developmental question, youths under the age of 14, according to these data, are at risk for potentially having impaired capacities to be competent. Again, not determinative, but it raises a warning flag that you want to investigate further. So if we were to think about ways that you might raise these issues, that would be consistent with the scientific data, okay? It would not be correct to say juveniles are less competent than adults as a group, or that young adolescents are incompetent as a group, but it would be consistent with the data to say that kids 15 and under are at greater risk for incompetence, that kids 14 and under are at greater risk for incompetence, okay? So the scientific data is going to be talking about probability. Let's talk about the connection between IQ and incompetence. Okay? Again, by definition, this does not mean that kids with low IQ or mental disorders are incompetent, but it does indicate that they are at greater risk for incompetence, even those 15 to 17-year-olds, all right, that I indicated from this research, don't look that different from adults in their performance. If they have low IQ or a mental disorder, that double whammy kicks in, and they are at greater risk than similarly low IQ adults for incapacity. Okay? So ways of thinking about these things. Let's briefly talk about legal experience. Okay? Our data do not indicate that youths who have court experience or arrest experience are more likely to be competent. We don't find a relationship between experience and competence. Okay, let me, there are a couple of questions that came up across our webinar, so let me see if I can deal with those, and hopefully I'll be repeating them correctly and responding correctly. So we have one comment that suggests that I always hear a quote, "He knows right from wrong." But would it be true to say that's not enough? Great question, and this data would argue that that's not enough. And actually, as I'll show in a couple of slides, one of these things that these results do not say, they don't say that kids cannot distinguish right from wrong, okay? It's talking about these capacities that go beyond that right versus wrong. So I'll come back to that in just a moment if I can. All right, and the second question asks about intellectual knowledge versus behavioral response and the ability to follow that knowledge. And if I'm interpreting this correctly, this is exactly something that we've been interested in studying, which is knowing and doing are two different things. And so that's in part why we were really interested in this study in not just assessing kids' knowledge, but in having them talk about what they would do in certain situations. And based on these data and then some other data, if we have time to get to them, I'll get to them at the end. We've tried to assess kids' knowledge about trials and about interrogation that goes beyond the basic legal standard about being competent to waive a right to talk about the behavioral implications, right? So if you waive your right to remain silent, or if you're talking to a police officer, does it mean once you've started talking, can you stop, right? So trying to help discern whether kids understand what are the implications of that right, not just you have the right to remain silent means you don't have to talk. And we do find that there are some age-based differences in kids' understanding of what it means to remain silent or to waive your right to silence. So hopefully we can come back to that for a few minutes a little bit later. And hopefully I dealt with those questions or interpreted those questions correctly for you.
And I would also add here that I think that there's probably an assumption that when we're talking about competency to stand trial, we're literally talking about competency to stand trial. However, because there is also this transfer proceeding that many kids face between juvenile and adult court, whether it's a transfer from juvenile court to adult court, or in many jurisdictions where juveniles have the opportunity, once charged as an adult, to ask the criminal court judge to send the case back to juvenile court, we're seeing an increasing number of attorneys raising the question and judges being amenable to considering the question about even juveniles' competence to participate in a transfer proceeding or to be subject to a transfer proceeding. So tomorrow, in a subsequent webinar, we'll be talking more specifically about transfer issues, but I just wanted to put that out there as being a component of all of these competency issues that Dr. Woolard is going over.
Absolutely. Thank you for that, Marsha. And that's absolutely right, that this research I'm talking about was grounded in the initial legal standard of competence to stand trial, but really much of this work is really trying to raise the question about what these capacities might indicate for a variety of circumstances and for the capacities of kids to be effective as defendants in a variety of circumstances. So thanks very much. All right, I'm going to jump to talking about a little bit about the research and the psychosocial factors related to culpability and responsibility, and then we'll leave some time for some additional questions at the end of our hour. So let me jump ahead a couple of slides and talk a little bit about mitigation. Now, this is my attempt to talk about the legal standards relevant to mitigation, and that's like a non-choir member preaching to the choir. So I'm going to skip this slide for the moment and just talk to you a little bit about the culpability study and the results that have come from that. And this is some of the research also, as Marsha was mentioning, that contributed to some of the reasoning and the argument in the Supreme Court cases that she described earlier. It took us a long time to get here in talking between the legal scholars and the practitioners and the scientists, because as you can imagine, it's hard to scientifically study committing a crime for lots of ethical and practical reasons. So we were really interested in studying some of the dimensions that seemed relevant to mitigation, okay, to really understanding the psychosocial capacities of kids and how they develop and how that might influence how we think about them in terms of mitigation. So here we had about 900 individuals from ages 10 to 30. These were folks that were not currently involved in the criminal justice system. Okay? Here we were interested in understanding normative or normal development. What do these capacities look like throughout adolescence into adulthood? We did not use a group of folks who were in the criminal justice system, in part because we thought if we found differences, the resulting explanation would be, well, of course you found differences, that's why they're in the system in the first place, right? So we were really interested in understanding the developmental aspects of executive function. So each of these folks took both questionnaires and computer assessments about the psychosocial factors that we were talking about. Okay. This chart is simply so that you have it as a reference if you're interested, but what I want to emphasize from this is that we had about an equal number of folks across the age groups from age 10 to age 30. We were interested in going well beyond what we thought the original research suggested brain development would continue into the mid-20s, you remember I mentioned, so we wanted to make sure that we caught the tail end of that curve, so we went up to age 30. That all of the age groups were comparable demographically in terms of race, ethnicity, sex, IQ. We drew from neighborhoods in the 5 cities at the average to low average end of the socioeconomic scale and the education scale. So this was not a bunch of folks who were getting postgraduate degrees somewhere that participated in the study. About equally split in terms of male and female and representations of the major racial and ethnic groups in the neighborhoods and communities where we were working. Okay. I've organized this slide to track those two systems that we talked about at the very beginning, the cognitive control system and the socio-emotional system. So you can see that the socio-emotional system, we were measuring things like risk-taking, sensation-seeking. Here we flipped it to talk about it as resistance to peer influence. Okay, so this is just the ability to push back against peer influence as opposed to susceptibility to peer influence. With the cognitive control system, impulsivity, okay, future planning, being able to think ahead. And then we also included assessments of IQ, of working memory, your ability to hold things in memory and so forth, because we know that those are important as well. So I'm going to jump right to the end of the study to show you the results. Perhaps somewhat disappointingly to those of us who are over the age of 16, the intellectual ability measures suggest that that peaks at around age 16. This is kind of standard IQ, and then sits pretty much where it is through adulthood. There is some recent research that's come out of the UK that suggests there is some movement in IQ, but not dramatic movement in IQ in young adulthood. Okay. Those cognitive control and socio-emotional factors that I was just describing, we measured them both by having folks answer questions about them, and we gave them tasks on the computer that they had to engage in that, unbeknownst to them, measured those same kinds of things. Okay, so we gave them a game that was kind of like a gambling game to measure their risk-taking, okay, and so forth. So we had both the self-report measures, the questionnaire measures, and their behavior on the computer, which timed what they were doing and kept track of what they were doing, and combined all of those into one psychosocial maturity score. So all the details are in the papers, and I'm happy to share those with folks who want them, but I think it might be more useful at this point to simply talk about that overall score of psychosocial maturity. And this is the graph of that score. So across from age 10 to age 30, what you can see is kind of a little U-shaped curve down there in early adolescence, and then a continued steady climb. And contrary to our prediction, where we thought we'd see some leveling out into young adulthood, maturity continued to increase well into age 30, and who knows what would have happened if we'd had 30 to 40-year-olds in the study. I want to comment down here because some folks have asked around the 10 to 11-year-olds, it looks like they might be a little more mature than the 12 to 13-year-olds. There's a little bit of a U right there. Our best interpretation of that little dip right there is what my colleague Beth Kaufman calls pseudo maturity, which is that when we ask questions of 10 and 11-year-olds about risk-taking and so forth, that they know what all of the right answers are and have learned well and say, yes, it is bad to do these risky things. As they moved into early adolescence and mid-adolescence, they begin to experiment with some of those things, begin to learn that they might not be quite as horrible as their parents have told them are, but they begin to gain their own experience a little bit with some of these activities. So that's what we think that little dip is there from 10 to 11 down into 12 to 15, but then continues through that maturing process, again, well into late adolescence and young adulthood. Okay? So just as a reminder, these are the kinds of developmental factors that are combined into that measure of psychosocial maturity. The degree to which folks can resist peer influence, the degree to which they are compliant with authority, that they can think towards the future, planning and foresight, that they can both identify risk and then decide whether doing something risky is good or bad, and has good or bad consequences for them, and the degree to which they can control their impulses. Okay? All of these things, remember from our early discussions, are things that are maturing throughout adolescence into young adulthood. Okay? So then an obvious question would be, well, you know, if kids have got the IQ pretty much by age 16 and can be about as smart as adults, why do they do such stupid things when we think about risky behavior? And our best explanation of this is putting those two graphs together. Okay? So putting the IQ development and change on the same graph as the psychosocial maturity, you may not be able to, you can't see me pointing at the screen right here, but you can see that gap between the red and the blue lines. Okay? And this is where we see that kids may have the intellectual capacity, but they don't have the maturity or the experience to be able to regulate and use that capacity well. So that's where we think the challenge is, and where the adolescence challenge is that they can, to use a driving analogy, they can reach the gas pedal in the car, right? But they haven't necessarily developed all the capacities to be able to drive wisely or effectively. Okay? And again, I want to point out here that this is a normal or normative thing. Okay? This is, on average, what all adolescents are like. Okay, so what does all of this mean? And again, I'm jumping to the conclusions of the data and just giving you a couple of highlights from the data, but there's lots more detail if you're interested in looking at that. So to draw conclusions from the culpability study then, it suggests that this adolescent time period is characterized by that socio-emotional system. Remember, that's easily aroused, high highs, low lows, rapid cycling, highly sensitive to social feedback, okay, sensitive to peer feedback, sensitive to what authorities may or may not be doing, okay? It's characterized by a still immature cognitive control system, right? That impulse regulation and so forth, that's still developing during this time period as well. So as a result, then, by their very nature, teens are less able to control their impulses, are less able to resist their pressure from peers, less likely to think ahead multiple steps when they're considering a decision or considering a consequences, and they're more driven by the sensation seeking and the thrill of rewards. Teens in these studies, teens are much more sensitive to gains or rewards than they are to losses or potential negative outcomes, all right? The possibility of winning overwhelms the possibility of losing, if I can simplify that a little bit in that way, okay? And we didn't do the brain research, the brain scanning in this study, but combining this research with the brain research that has been occurring in labs across the country, we have a pretty good understanding of the neurobiology underlying these systems, right? The socio-emotional system and the cognitive control system that I was describing. Okay. Now this will get us back to one of the questions that we had earlier after the competence. What does this data not mean? So from the science perspective, what do we not say as a result of this data? This doesn't mean that adolescents don't know right from wrong. Okay? It doesn't mean that they're exactly the same as young children. It doesn't mean that they shouldn't be held responsible for their actions. Okay, so this is not arguing for a complete lack of responsibility because they are immature. It doesn't mean that all juvenile offenders are the same, so I mentioned that your individual client falls somewhere in this realm of possible adolescent behaviors and outcomes. But is this research then still important for here juvenile justice policy, and we can talk about criminal justice policy dealing with juveniles as well, okay? Yes, the brain research combined with the behavioral research helps us understand that kids are not just choosing to do these things because they want to be non-compliant or they want to be annoying, that there are biological bases for the differences between adolescents and adults in these capacities that are developing. But of course, we know that under the law, it's behavior, not anatomy, that matters. We're not at the point where we can do a brain scan of someone and say their brain is not fully developed, or they're fully developed in risk perception but not in future orientation. Okay, that's simply not there. I'm not sure if it's ever going to be there. The brain research is important. It's still somewhat early in its development. Okay, so there's still a long way to go in interpreting it. But one of the things I think that's important is that the behavioral research and the brain research are all triangulating or coming in on the same kinds of conclusions, okay? That they're all consistent in the conclusions that they draw about the differences between adolescents and adults, okay? But that brain research cannot do some of the things I was just mentioning. It can't tell us exactly where to draw an age boundary. It can't tell us that Johnny is immature and Joey is mature. It can't give us any indication about a legal finding of guilt. We cannot see that on a brain scan. It doesn't show us bad brains or brains that are going to continue to reoffend versus those that are going to desist. And it doesn't substitute for an actual assessment of an individual's behavior. So again, all of this is to say that it's not going to be able to pinpoint for an individual client whether they're amenable to treatment, they're amenable to change, but at the same time, all of this is consistent with the behavioral research about development that's been building for the past several decades. Okay, again, all pointing to our understanding that adolescents as a class, okay, as a group, are different in these capacities compared to adults, and that as a group, most of them are likely to grow out of these differences once they mature into adulthood. Okay. So with that said, how should what we know inform policy and practice? Well, these are some of the conclusions that come from me and are consistent with some of the recommendations that folks involved in the research have made. That test again, we can now empirically say that juveniles are indeed different from adults, that prior to 16 we see differences in intellectual capacity still growing, as well as the psychosocial, cognitive control, and socio-emotional factors. After 16, even if IQ stabilizes, that we still see those psychosocial and emotional differences. That because of this research, that we would argue that we really need to be concerned about the capacity for kids under age 16 to be competent, to stand trial. That psychosocial immaturity appears to be relevant to mitigation and criminal responsibility, even among older adolescents, as we saw that development continuing well to the mid to late 20s. That we know from these and other studies, some of the studies that I didn't describe to you today that look at amenability and desistance and so forth, that immature juveniles, most of them will grow into mature adults and mature law-abiding adults. And so our responses to these kids in the system should be crafted in a way that holds them responsible, but doesn't harm that capacity to grow out of the immaturity and to grow into responsible adulthood. I think maybe what I want to do is pause here now. And Marsha, I don't know if you have any comments or if we have comments from the folks that are here in our live audience or things that have come up from the webinar. I see a small list of questions that are coming up.
And while we're waiting for those questions, what I would say, I think, at the conclusion of Dr. Woolard's comments is that if I had a graph, my graph would show a line going up, which would be the increase and the push of more juveniles into the adult system, the imposition of adult sanctions on juveniles, treating them more like adults and more, again, imposing criminal sanctions on them, and a line that hits that upward bar, that is the Supreme Court, that has put some constitutional brakes on what and how far states can go in terms of imposing adult sanctions on juveniles, and in terms of, I think, with the recent decision in JDB versus North Carolina, which we briefly mentioned being the case about requiring that age be considered in thinking about whether or not juveniles are in custody, the Supreme Court has looked at this research and said, there's a line that we think can't be crossed here, and that line to some degree is driven by its own interpretation, not only of the Eighth Amendment and restrictions on sentencing practices, but also its interpretation actually of the Fourth Amendment and Fifth Amendment traditional due process and other Fourth Amendment considerations. So I think that what we see here is this very interesting intersection between science and research and legal practice, going back to Dr. Woolard's original graph about the Yarborough case, showing us really the building blocks of how we connect research to legal analysis, to policy and practice, and ultimately, hopefully, some progressive or favorable decisions that take account of that research. And I think that what I would also underscore is that actually we're in a time that's incredibly dynamic and incredibly fluid. We don't know where this research is going. There's research that is ongoing even now that is continuing to teach us more about the capacities, the culpabilities, the competencies of juveniles, the characteristics of juveniles as offenders, and much work to be done. And again, I think much work for the criminal defense bar to be engaged in, as you are really the front line. You are the ones representing kids in the adult criminal justice system. It will really be your job to figure out where some of these next frontiers are.
Absolutely. If I can follow on that with a small plug for research practitioner partnerships, that if you certainly the kind of research that we as scientists can do depends heavily on our learning from you all about what these issues are and about what is relevant. So I'd strongly encourage you, if you have the opportunity or if you can, to help those of us that are trying to do the research, create research that's going to be theoretically sound, but that's going to be meaningful and relevant to the kind of work that you all are doing. Okay, we have a couple of questions, so I'm going to read those, and they're for both of us, I think, Marsha. So let's start with this one. So there was a question about competency and young adolescents. So here talking about those early to mid adolescents, 11 to 15. And the question, does your research suggest that for particularly young defendants, the best challenge may be that the juvenile is too impaired to stand trial? Or I guess this would mean incompetent to stand trial. Marsha, do you want to talk about that from the legal perspective?
Yes, and I think that this is a great question that is going to be very jurisdiction specific. So in the adult criminal justice system, obviously every state has a statute that incorporates the Dusky standard, that provides for remediation or not, that provides for convictions of not guilty but insane. And with respect to issues about juvenile incompetency, I would say that our legislatures are far behind where the criminal justice system is, and that legislatures are struggling with the proper resolution if a juvenile is found incompetent to stand trial. And so there have been some suggestions, some from the MacArthur Research Network, about how this issue might be dealt with. One is, and I think this is particularly probably attractive with respect to very young juvenile defendants, is to think about the dependency system or the child welfare system as being an alternative place for juvenile defendants who are too impaired to stand trial to be placed. The reason for this is because the child welfare system is a system that still allows for the possibility of supervision, for intervention that may address issues of accountability and responsibility. There is also some discussion, has been some discussion within the research and practitioner community about, even for juveniles who are older, who are in the adult criminal justice system, if there's a finding of incompetency to stand trial, perhaps that juvenile could still be found competent to stand trial in the delinquency system, where the argument is, or the theory is, that the consequences are somewhat less severe. Certainly the sentences are less severe, increasingly collateral consequences not so much less severe. And so that's a justification for imagining a scenario where the juvenile, too impaired or incompetent to stand trial as an adult, could be brought into the juvenile justice system and found accountable. I think that this is a particularly fluid area, I would say, because of the fact that in so many jurisdictions we don't have legislation that gives us a roadmap for how to handle these cases, for whether or not, for example, there are some very few jurisdictions now that are looking within the juvenile justice system cases of incompetency and actually providing an outside timeline. If the juvenile is not remediated within a year or two, the charges are actually dismissed. Whether or not that would be an acceptable resolution in the adult system, I think, is one that we're really still looking at.
Great. Yeah. So I think as Marsha mentioned, coming out of the research, our interdisciplinary group had laid out some options in a way that, following from this, that we could see as potential ways to respond. But it's certainly a legal and a policy question in terms of, once we identify these differences at the policy level, how do we approach that? And at the individual case level, when you have a client in front of you, what's the best response to that client?
And I would also add, as a matter of practice, that one of the other issues that we've seen and that we have talked with colleagues about is that there are always situations where a juvenile may appear to you, this is another duh moment, the juvenile may appear in criminal court to you as a criminal defense lawyer pretty obviously incompetent in terms of their inattention, their doodling, their apparent lack of understanding about what's going on around them. But unless you as the criminal defense lawyer raise that issue of incompetency, or unless if you fail to raise it, if the judge raises it, these are issues that can be raised on appeal, because there is certainly Supreme Court case law that is very clear as a matter of due process. Incompetent defendants cannot be held to stand trial. And so if you have an incompetent juvenile, if you either are representing this juvenile at trial, or as I mentioned, if you get this case on appeal, if there has not been an adequate assessment and an adequate querying of whether or not that juvenile was in fact competent to stand trial, these are very significant issues that can be raised at a later date, because in essence that may well be a violation of the juvenile's constitutional rights, due process rights.
So maybe with a natural follow-on to the next question, someone asked if we could talk a little bit about what is involved with an individualized assessment and when it might be wise to do one. So certainly competence would be an example of that circumstance. My best recommendation for you all in terms of what is entailed in an individualized assessment, and from the clinical side, and I can't remember if I mentioned, but I'm not clinically trained, I'm developmentally trained, is to refer you to a short book that was put out by Tom Grisso, perhaps the dean in the social science world of thinking about these competence issues, in which he has written a small handbook for lawyers about understanding mental health assessment and what you want to ask for and what you want to look for. And we can certainly put that link up on the website to make that available to you all. I want to jump back just for a quick second about this issue. Actually, maybe Marsha, maybe you could talk for a moment about kind of from a lawyer's perspective, you know, when you think about pulling in a mental health professional for an assessment, and I'll try to jump back in my slides to one or two that I have about clinical assessment specifically.
Well, I think that we certainly recognize that for the criminal defense lawyer, you're always making a judgment call about whether or not you want to in fact subject your client to a competency assessment, because if the only resolution of that competency assessment, if they're found incompetent, is a very long period of incarceration or hospitalization because of mental illness, you may make a decision, understandably, that you choose not to go that route and think of other ways to resolve that litigation that may be more favorable to your client. So certainly what we're doing here today is giving you tools, we hope, that you can make use of, but recognizing that between you and your client, you will make these kinds of decisions on an individual basis. The other point that I would mention, and I would assume that Dr. Woolard would back me up, is that the kind of competency assessment that I think you're going to post in the book that Tom Grisso has created, which is really a guide for how to use mental health assessments specifically with reference to competency issues, is different than a brain scan.
Yes.
And I think that what's been clear in the remarks today is that many of the findings that we have come up with respect to adolescence, both in terms of the neuroscience and the behavioral research, are averages. That adolescents on average are this or that, behave in this way or that way. We can make these conclusions about them on average. To run the risk of conducting a brain scan on your client in the hopes that it will show that your 16-year-old really does look like what the neuroscience says either an average 16-year-old or better yet an average 14-year-old looks like, if your client turns out to be more mature and looks like an 18-year-old, you run the risk, of course, of then losing the value of that argument with respect to the average expectations of adolescents. So we have been cautious, I think, as a community in encouraging that kind of very detailed assessments of clients, because we think that it's not likely to be helpful in terms of what it is that we know on average about adolescence, what the Supreme Court certainly has recognized on average, what science tells us about adolescence on average, and we know that it's appropriate to take account of that information in making the kinds of sentencing and policy and culpability decisions that we're making. So I just want to point out that that's an assessment that's very different than the kind of behavioral assessment and traditional mental health assessments that you all are familiar with respect to competency generally.
Great, and to follow on that, one of the slides that I jumped over earlier, that I think I want to emphasize for you all to follow on what Marsha was saying, in that if you are looking to obtain a forensic assessment of your juvenile client in adult court, that you really want to find a mental health professional that has developmental expertise in forensic evaluation, okay? And folks, there may be incredibly qualified, fabulous folks in the adult system who do fabulous adult evaluations, but you want to inquire as to whether they do developmental adolescent evaluations. Don't just assume that they do, right? Because you'll want them to have specialized knowledge of adolescent development. They need to know how to interview children and adolescents, which is different than interviewing adults. You want them to be familiar with the developmental research that we just walked through, okay? So that they know that they want to be asking about risk perception and future orientation and executive function and assessing that, which may or may not be part of the standard adult assessment protocol that they engage in. You want them to be familiar with developmental assessment so they can place the responses of your client in the larger developmental context, okay? So to talk about what's average and what's not and where your client fits in, and so that they know which psychological assessment tests to use, because there are going to be different tests for adolescents than there are for adults, okay? So again, you want to really ask questions to make sure that you've got someone that has the expertise that you need to work with your adolescent client in that regard.
We have one last question. An additional webinar that we will want to do. And the question has to do with seeing and appreciating the consequences of an action and asking the question whether or not it is reasonable to hold a juvenile to the same standard of recklessness as an adult. This is a great question because in JDB versus North Carolina, the Miranda case, the Supreme Court specifically recognized in its ongoing jurisprudence that kids are different, that there is a reasonable juvenile for the purposes of the Miranda custody analysis that is in fact a different test and a different individual than the reasonable adult. And there are certainly many of us who have been looking at the implications of JDB and have come to believe that standards of recklessness, other situations in which reasonableness or the reasonable person standard is relevant, issues even of felony murder, provocation, duress, that all of these elements or characteristics of offending by individuals in this country, that if they are juveniles, that we think that there is traction from the Supreme Court's decision in JDB to begin to talk about a reasonable juvenile or a standard of juvenile reasonableness or recklessness, as this particular question raises, that might in fact look different and might justify a different outcome, a different set of arguments than you might make if in fact you were defending or representing an adult criminal client. I do think, and as a nod to Malia, I think that this is something that we could do a whole session on, and perhaps we'll have an opportunity to do that in the near future.
Great. I think this brings us close to the end of our time, so Malia is coming up to close us out.
I wanted to just thank you all on behalf of the National Association of Criminal Defense Lawyers, the Juvenile Law Center, and the National Juvenile Defender Center for joining us, and I hope that you all can come back tomorrow for our sessions on transfer and sentencing, which begin at 1 o'clock Eastern Time with transfer and 3 o'clock Eastern Time for sentencing. The same webpage should take you there, and thank you all very much. Thank you.
Thank you.
Thank you.